Hello everyone, welcome back to my channel. Thank you for joining me in this live section, guys. Yeah, we came live, but you guys you were not hearing me, so we had some little network issues. That is why I'm here again. So guys, if you were here before and you left because you cannot hear me, you can actually come back because we are live now, guys. I have a lot to tell you guys. I have a lot to tell you guys. Guys, a lot is happening. So sorry for that, network problem. We are here back again, to update you on what is going on in Nnamdi Kanu's case. And I would love you guys are informed because I wouldn't want anyone to miss this at all. I wouldn't want anyone to miss this at all, guys. A lot happened, and I'm here to share with you guys, what you don't know that happened in Nnamdi Kanu's case, and that is why he's still in detention till today. So, guys, if you were here and you left because you were not hearing my voice, yes, I'm here again. I know that you guys are hearing me perfectly. So, I'm here to expose what is going on in or what happened in Nnamdi Kanu's case that you don't know. So, there are two of his ex-lawyers that sold his case to the federal government, which I'm going to be telling you guys in this live section. There are two of his lawyers who sold Kanu's case, and I'll be telling you these lawyers in the comment section. Already, you can already see them. You can already see them in the in your screen. Number one of them is okay. Their names are Mike and Ifeanyi Ejiofor. These are the two people. These are his ex-lawyers who sold Kanu's case to the federal government. And in this live session, I'll be telling you how these people sold Kanu's case. They failed to do their job. In fact, they failed as a lawyer. And that is why Kanu is in detention up till now. So guys, welcome to my channel. If you're new to this channel, hit that subscribe button, like and share this video so that others, YouTube can actually recommend this video to others to also watch. So now, viewers, now listen very well that today, we are not asking question of the legal jargon or who first coined the face of the extraordinary redemption of Kanu. No, in this video, it's about something far more serious, a historical legal victory that could have ended the detention of Nnamdi Kanu in 2022. Now, in this video, I will tell you how, what would have ended Kanu's trial or detention since 2022 and what happened. The lawyers that sold his case to the federal government, that is why Kanu is in detention up to today. If you have anything to say, drop it under the comment section. Let's talk about it. So now, like I said, we're going to be talking about a historical legal victory that could have ended Kanu's case, since 2022, and the facts that happened afterwards. Now, we're talking about the Court of Appeals ruling in October 2022, a judgment that discharged and acquitted Nnamdi Kanu and gave a binding order to set him free. Yes, but here is the burning question, guys. What did Mike, the lawyers of Nnamdi Kanu, as at then in 2022, what did the lawyer do after the appeal court discharged and acquitted Nnamdi Kanu? What did they do after that? What did Mike and Ifeanyi Ejiofor actually do to enforce it? To enforce that ruling, what did they do? No theory, no interview, no press release. I mean, tangible legal process. They did not take any tangible legal step to physically secure Kanu's release from DSS custody. That is what I'm here to tell you guys. These two lawyers of Nnamdi Kanu already they're not his lawyer again. These two lawyers, we have to blame them for Kanu's endless detention till today. Because when they were supposed to act, they had an opportunity to permanently, rescue Kanu from that detention, but they failed to act as the lawyers. It would like to say that the federal government outsmarted them. That is how I'll put it. The federal government outsmarted these lawyers. And that is why Kanu is in detention till today. Guys, stay around, hook around. I have a lot to tell you guys. See, so now these lawyers, when appeal courts acquitted and discharged Nnamdi Kanu, what did they do? Which legal step did they take physically to secure Kanu's release from the DSS custody? The answer is that they did not do anything to secure. They were supposed to do something to secure Kanu's release permanently. If they had done that thing, it would not give room for the federal government to come and file a stay of execution. Are you getting me? If they have done what they were supposed to do as a lawyer of Kanu, the federal government will not have any space to file a stay of execution. So now let me not gist you. After the October 2022, when appeal courts discharged and acquitted Nnamdi Kanu, the federal government, the lawyers were outsmarted by the federal government. The federal government, filed a stay of execution. That is why Kanu is in detention now. So in October 2022, after years of legal battle, the Court of Appeal delivered what many called a landmark judgment. Yes, the court not only ruled that the extraordinary detention of Nnamdi Kanu from Kenya was unlawful, it went further to order that he be released immediately, like as soon as possible. That was the judgment. Not only that his redemption or extraordinary redemption was illegal, but then they said that the judgment was that he should be released immediately. The order was clear for everyone, any lawyer to understand. It wasn't just a suggestion, it was binding. The judgment, the order was not just a suggestion, it was binding, and it was powerful enough to end his detention right there at that moment, right there and forever. But at that moment, the legal team of Kanu, led by Mike San, you can see the last person on your screen is the Mike. The second person, or the person at the middle on your screen, is Ifeanyi Ejiofor. They had all the tools needed. When this appeal court, acquitted and discharged Kanu, the legal team of Kanu, which is Mike Asaden and Ifeanyi Ejiofor, they had all the tools they needed. They had the judgments with enforceable teeth. They had the court authority on their side. They had the country as well, and the international community watching. What did they do to secure Kanu's release permanently? They didn't do anything. Now, this was what we were expecting them to do as lawyers. This was what we were expecting this Kanu's legal team to do. We were expecting them to do, number one, filing for immediate enforcement in the trial courts. Now, after the judgment by the appeal court in October 2022, we were expecting these lawyers, two of them, Mike and Ejiofor, to do these things which they failed to do. Number one is filing for immediate enforcement in the trial courts. Guys, stay with me. I have a lot to tell you guys. Now, filing for immediate enforcement in the trial courts, compelling the DSS to comply. This was the first thing we were expecting them to do. Two was serving Form 48 and Form 49, the legal process for contempt of court in Nigeria, forcing the DSS boss and the Attorney General to face jail term for disobedience. This was the second thing they need to do after the judgments of, appeal court in October 2022. I'm mentioning the things they were supposed to do, which they did not do. Filing an urgent motion at the Supreme Court to stay any attempt to suspend or overturn the judgment. Guys, if the then lawyers of Kanu did these things, Kanu will not be in detention by now. Yes, because it will not give room for the federal government to file a stay of execution. It will not give room for them, especially this point, filing an urgent motion at the Supreme Court to stay any attempt to suspend or overturn the judgment. If they have done this particular point I just said, it will not give the federal government a room to, file a stay of execution. And that is one of the reasons why Kanu is in detention till now. So this is how the lawyers sold Kanu's case to the federal government, because they refused to do all these things. They didn't do all these things. The fourth thing they are supposed to do also is mobilizing international legal pressure, notifying the UN working group on arbitrary detention and African Commission on Human Rights, People's Rights on the Biden judgments. And lastly, they were supposed to, applying directly for the release warrants. They would have just walked into the DSS headquarters with, court bailiffs to enforce the order. But guys, they did none of this. If they have done these things, Kanu will be released since 2022, and the federal government will have no room to come and file a stay of execution. Because, why Kanu is in detention till now is because after the appeal courts, gave that judgment, the federal government outsmarted the lawyers and then they filed a stay of execution. That is why our Oyendu, Nnamdi Kanu, is still in detention till now. Now, what did these lawyers do? Mike and Ifeanyi Ejiofor, what did they do? Instead of taking this bold step to secure Kanu's release permanently. What did they do? They gave interviews, they had press conference, they issued statements to the media. It's good though, but there are actually important things to do before all these things to secure Kanu's case, permanently. Meanwhile, the federal government filed a stay of execution, and somehow that became the perfect excuse for total inaction. Because the federal government filed a stay, you see how the federal government outsmarted Kanu's lawyers, the then lawyers of Nnamdi Kanu. You see how they outsmarted them? Instead of them to take necessary steps to secure his release permanently after appeal courts discharged him and acquitted him, the federal government outsmarted them and then filed a stay of execution. And now it is somehow an excuse, a perfect excuse for total inaction in Kanu's trial. Now let me clear you. A stay of execution application is not the same as a granted stay. Now, until a high court suspends the ruling, the judgment stands and it must be enforced. That window between the judgment and the stay order was the golden moment to act. It was the golden moment that the lawyers of Kanu should have acted, but they lost it. Let me come again. The moment when Kanu's lawyer should have acted was between the judgment and the stay of order. But then that was the perfect time to act to secure Kanu's release, but they lost it. The federal government outsmarted them. Instead of taking both steps, like filing for immediate enforcement in the trial of courts, in the trial courts, compelling the DSS to comply, they didn't. Instead of serving Form 48 and Form 49, the legal process for contempt of courts in Nigeria, forcing the DSS boss and the Attorney General to face jail time for disobedience. Instead of filing an urgent motion at the Supreme Court to stay any attempts to suspend or overturn the judgment. And instead of mobilizing international legal pressure, notifying the UN Working Group on Arbitrary Detention and African Commission of Human and People's Rights of the binding judgment, instead of applying directly for the release warrant, walking into DSS headquarters with court bailiffs to enforce the order. Instead of doing all this, what did they do? The lawyers, they gave interviews, they held press conference, they issued the statement to the media, which is actually good, but that was not the important thing to do at that point. So because of, the federal government now had the opportunity, they outsmarted these lawyers, the then lawyers of Nnamdi Kanu, and filed a stay of execution. Now, this thing they just did, somehow it became the perfect excuse for total inaction in Kanu's case till today. Now, instead of answering this simple question, instead of answering these simple questions, what concrete step did you take to enforce the Court of Appeal ruling? Instead of answering it, the supporters of Mike and Ejiofor has turned their attack on our lawyer Ejimako. Why? What's the business of Ejimako? It was in your hands. You guys had the golden. These people were the then lawyers of Kanu. They had their golden opportunity to secure Kanu's release, but then they sold it to the federal government by not taking important step, concrete step to release Kanu, finally, permanently secure his release. They did another thing, and then this federal government has smarted them to file a stay of execution, which is the reason why Kanu is still in detention till today. Now, by October 2022, people that are actually, accusing Aloy or coming to attack Aloy, by October 2022, Aloy Ejimako had already been deliberately sidelined from the Abuja defense team. Let me come again. People that, people that is supporting Ejimako. By October 2022, Aloy Ejimako had already been deliberately sidelined from the Abuja defense team. He had no access to the main case file. These two lawyers, Ifeanyi Ejiofor and Mike, these two lawyers had access. They were not sidelined. They had access to the main file, the main case file. But Aloy Ejimako did not have access by then in 2022. So nobody should come and be attacking him for any reason. Aloy Ejimako, as at then in October 2022, Ejimako had already been deliberately sidelined from the Abuja defense team. He had no access to the main case file. He wasn't on record in that proceeding. And without a brief, he couldn't walk into court to move enforcement unless you expect him to crash the hearing like an uninvited guest. He had no access to Kanu's trial as at then in 2022. So you see, so now let's compare these results. Let's compare these results. The Abia State High Court win. Abia State High Court win. Aloy Ejimako, based on that was, he won that case based on extraordinary redemption. And then the Court of Appeal win by, Mike and Ejiofor, direct order to free Kanu. That was the direct, they won that case. The Court of Appeal win. Now let's compare this thing. One judgment exposed the illegality. The other had the legal force to set Kanu free. Understand me? We are comparing these two results of Nnamdi Kanu. The cases he won by the lawyers. Now, the Abia State High Court win that was led by Aloy Ejimako based on the extraordinary redemption, and then the Court of Appeal win, Mike and Ejiofor, the direct order to free Kanu. One judgment exposed the illegality. One judgment exposed the illegality, the other had the legal force to set Kanu free. Only the second could have ended his detention overnight. I mean, the one led by Ejiofor, these ex-lawyers of Kanu, Ejiofor and Mike. I cannot even pronounce his surname, if not. I think his name starts with you. If you know him, you know his name. But I know him with Mike, and the other one, Ifeanyi Ejiofor. The second case, which is the Court of Appeal win, the direct order to free Kanu, this second one could have ended his detention overnight, but it was never enforced. The two lawyers did not take important step to enforce it. This is why we say the failure belongs entirely to those who had the conduct of the case at that time. That is why we say the failure belongs entirely to those who had the conduct of the case at that time. And who had the conduct of the case at that time? It was Ifeanyi and Ifeanyi Ejiofor and Mike. These are the lawyers of Kanu that had the conduct of the case as at that time. The second, that case would have even, ended Kanu's detention overnight, but it was never enforced. That was the problem. History will remember that moment when freedom was within reach, yet was allowed to slip away. So to the defenders of that failure, here's the question we are asking again. I mean, we're asking this question. I feel they need to come out and actually ask this question. Honestly, answer this question, Mike and Ejiofor. We actually need them to come and answer this question, because there was the slightest opportunity, they had to, release Kanu, unless they deliberately did it. We're asking them this question again. After the Court of Appeal freed Nnamdi Kanu in 2022, what exactly did they do? What exactly did Mike and Ejiofor, the lawyers of Kanu, what did they do to make it happen in reality? Until that is answered with evidence, not insult though. I don't know if you guys understand. Every other word is just noise. Until this question is answered, and every other noise of them come to say, release Nnamdi Kanu, this, that, just know that they are the ones that actually, it was in their hands. It was in their hands. Hey, somebody said something. Let's look at it. I just think all you guys are actually flowing. Somebody said, the thing is, many forces are behind his detention, especially politicians from the southeast. Hey, I will not doubt what this person said. Many people have come out to say it. Many people are behind Kanu's detention. It's not just these lawyers, though. Many, a lot, are behind this endless detention. You might be asking, Kanu, is his right to agitate now? And by the way, he has been in detention for so long, and they have not said he's a criminal, so they should release him. Many are behind this endless detention, which you don't know. Many people have come out to say that it's the southeast, especially southeast politicians. But then you cannot exclude these two lawyers that started, they had the opportunity to release Kano, but then they sold it. Now, with what this man said, take a look at this video where this man clearly stated the names of southeast politicians. This one is an ex-soldier of southeast politicians that are holding Kano till today. I will let you watch this video, guys. Sit and sit comfortably and watch this video from beginning to end. Take a look at this video.
Yes. Hello, Nigerians. They are trying to silence me, but with God, they failed to silence me. I want to analyze something concerning the arrest of Mazi Nnamdi Kanu. Everybody is just talking here and there about Nnamdi Kanu. But what is keeping Nnamdi Kanu in the prison today is saboteurs. Because of the saboteurs, some selfish people that will make the good movement of this nation, that will make the betterment of this nation, not to appear to the people of this nation. Nnamdi Kanu is a freedom fighter. You see that how Nigerian leadership are turning this country upside down. That every human being or the citizen of this country, they are not getting it right. You see that hospital, you are not well treated. You see that in police station, your case are not be well taken care of. Security everywhere. There is no security. He decided to say no, and he know the history, and he decided, let me get my own country, Biafra. And the history of Biafra, he makes that history that a lot of indigenous people of Biafra, they are fighting for this country called Biafra for a very long time before he was born. And he stood up. A saboteurs in the east. The people holding Nnamdi Kanu in Nigeria today, in the prison today, is not the government, it's not the president. How can the president hold Nnamdi Kanu when all the whole charges against him is not guilty to it? The people holding Nnamdi Kanu in this country today is the leadership, the leaders in the east, the governors. Let me measure. I am not afraid of anything. The governor of Enugu, your hand there for Nnamdi Kanu. The governor of Anambra, your hand there for Nnamdi Kanu. Hope Uzodinma, your hand there for Nnamdi Kanu detention. The governor of Abia State, your hand there for Nnamdi Kanu detention. Wike, your hand there for Nnamdi Kanu detention. Now, they hold Nnamdi Kanu, make it they know what? Release her. Una say, if they release Nnamdi Kanu, say, problem go there for East. How problem go there? Nnamdi Kanu there for detention, problem not there for the East. Is Fulani not killing the people of the Igbo land? Is Fulani not killing people inside East today? The governor of Enugu is an impotent governor. Fulani herdsmen is killing your people. You are not doing anything. You did not take any action. It was the youth that said they must gain Biafra. They are the one fighting. They are the one pursuing those Fulani away from their land. You will keep her because of selfish interest. Those people I just mentioned, they are behind the arrest. They are behind the detain of Nnamdi Kanu. They want Nnamdi Kanu to die in that prison so that anything concerning Biafra should not rise again. Is a lie. Nobody can stop the sun to shine. The worm when they eat cola, the worm when they chop cola, it they inside cola. So the people killing Nnamdi Kanu, the people that said Nnamdi Kanu will not be released, they are charging him reckless and nonsense charges. They are the governor, the House of Representatives that is represent all the whole senatorial district in the east. They are against him. They are the one that said Nnamdi Kanu will not gain freedom. That if they gain Biafra, them who is now the governor, so-called Nigeria, They will not have any political space in the Biafra. They will chase them away from Biafra because they did not start for them to gain Biafra. It's only Nnamdi Kanu and Samuel Ekpa that gain Biafra. So therefore, they don't want the Biafra to stand. So my advice to the IPOB today, Nnamdi Kanu is in detention, going to court every day. And you people are creating sit at home. Let me tell you today, sit at home will not solve the problem. Sit at home will not bring Nnamdi Kanu out of that place. Let me advise you people. I'm talking to you. If you know you are the commander in the IPOB, in the movement of Biafra.
So, guys, he heard what that man said. That man is actually an ex-soldier. Yes, he's an ex-soldier. He has been coming out to expose a lot of things going on in the military and then in Nigeria. And then he came out to actually expose this one concerning Nnamdi Kanu, saying the same thing that this person said here, that, the ones behind Kanu's detention are actually Southeast leaders. You heard him mention their names clearly. He mentioned the governor of Anambra State, mentioned the governor of Imo State, mentioned Wike, mentioned who else? The governor of Imo State, the governor of Enugu State. These are the people that are holding, he mentioned him allegedly that these are the people that are holding Kanu. And then this person also said another thing. He said, I can't disclose a lot, but trust me, the same people from there are behind it. I am sorry that's all I can say. Okay, we have actually heard you, and then we actually know all these things. Yes, thank you for dropping, your mind. If you have anything to say, feel free, to drop it under the comment section. Let's talk about it. Feel free to let us know your thoughts under the comment section. Let's talk about it. So now we're talking about, the lawyers of Nnamdi Kanu that sold his case to the federal government. Now they refuse to do one particular thing, and that is why Kanu is still in detention till today. Yes, and they will not deny the fact that it's not just these lawyers are still holding Kanu. There are people else, just like this Southeast governor that this person mentioned. These are the people also that we need to blame for Kanu's endless detention. So now, why we should blame them is because they are doing a lot in Aso Rock, having so many deals. But then when it comes to Nnamdi Kanu's case, nobody is speaking up for him. I mean, people Southeast governors, nobody is speaking up for him. What they can come out to say is that Nnamdi Kanu cannot end insecurity in Nigeria. So what are you trying to say? That Nnamdi Kanu should rot in jail, or he should rot in detention? Is that what they are trying to say? You can see. So now, like I said, like I was talking about the lawyers of Kanu that actually sold his case to the federal government. They refused to do important things. That is why the federal government, used that opportunity, outsmarted his lawyers, and then filed a stay of execution. And that is why Kanu is still in detention till now. That is why he's still in detention till now. Now, like I said, we'll be answering this simple question. Why, we'll ask these two lawyers these simple questions. And the question is, what they did. What exactly, when after appeal courts freed Nnamdi Kanu in 2022, what exactly did Mike and the Ifeanyi Ejiofor, what they do to make it happen in reality? Until these questions are answered with evidence, every other word is just noise. They're just making noise. Every other word is just noise. Every other word is just, trying to make noise. And the world will continue to see this for what it was: a historical legal victory wasted. A historical legal victory wasted. That was the golden opportunity they had to release Kanu, but then they sold it. Now, somebody said another thing. Like I said, please, guys, very soon, starting from tomorrow, I will start bringing up people, to come and share your thoughts. I will drop a link under the comment section to come and share your thoughts. I will bring you up to come and speak. You will speak up and tell me, you talk about your own view. I'll bring you up, and then you feel free, you talk about what you feel about this headline. You're going to join me to talk to a lot. So just feel free, anything you want to say under the comment, just drop it under the comment section. Let's talk about it. Now, this person said, the same people, let me show you guys. This person said, the same people oh, I think this person actually made mistake. So the same people where where they talk, okay, the same people where they talk say they kill their people. Most states in the north is free education to university. When I learned that, the team pay me. Okay, now if I'm to understand what you're saying that the same people that they said they killed their people most in the states, the same people where they talk say they kill their people, most states in the north is free education to university. When I learned that, this person saying that when you go to the north, you will see education, free education to university level. To university level. This is the same people that is saying that they are killing their people. That is, you say when he learned that, he was pained to hear this. Thank you for your idea. I really appreciate, share your thoughts on the comment section. Like I said, from tomorrow I will start bringing up people that will come up and speak. Yes, you come out and speak, you share your own ideas with us from tomorrow. So get ready for, we have a lot to talk about tomorrow. So like I said, these are the two lawyers, Mike Ejiofor and Mike and Ifeanyi. These are the people that sold Kanu. They had the opportunity to release him at that point, but they sold his case to the federal government. Now, the difference between a symbolic victory and enforceable victory, let me now tell you the difference. The difference is the Court of Appeal judgment in October 2022 was just okay. The time should be somebody said drop time because we'll be bringing up people from tomorrow to start speaking. So the time would be anyways, the time will be 2 o'clock. Yes, 2 o'clock in the afternoon and 8:30 in the night. Yes, we're going to talk about lots of things. So if you're free, join us. Let's talk about it. I'll bring people up. You will speak and let's know your own thoughts. You talk to your audience and share your thoughts with others. Let's know what you're saying about the headline we'll talk about tomorrow. So that's just it. So I'll still make this announcement by the end of this live section so everybody can get the points and be ready, and be fully prepared. So now, like I was saying, the difference between a symbolic victory and an enforceable victory is the Court of Appeal judgment is on October 22. Now, listen, the Court of Appeal, I'm trying to tell you the difference between a symbolic victory and an enforceable victory. There's a two big difference. And we wanted the lawyers of Kanu, to enforce the victory of Nnamdi Kanu, which they failed, giving the federal government's room to, they, in fact, will I say they bought the opportunity to, to file a stay of execution, which is affecting Kanu till today. Now, the difference between these two is the Court of Appeal judgment in October 2022 was not just symbolic. It was final and binding unless overturned by the Supreme Court. Once it was delivered, the DSS and federal governments were legally obligated to release Nnamdi Kanu immediately. Any delay in enforcement was a breach of the rule of law. The responsibility for pushing that enforcement in courts lay with his legal team. The responsibility for pushing that enforcement in courts lay with his legal team. I don't know if you guys understand. Now, the legal tool they failed to use after such a judgment, competent lawyers could have. That was, if you call yourself a competent lawyer, you should have that too. If you call yourself a competent lawyer, you should have the tool they are supposed to use to enforce that, judgment. Number two, which they, if you call yourself a competent lawyer, they should have was filed a form 48 and form 49. These are the tools they were supposed to use, which they failed to. Filed a form 48 and form 49 under the Civil Process Act of committal proceedings against DSS for contempt. This was 2-1. 2-2, which they're supposed to use, they failed to use it. Approach the Supreme Court directly for an order of immediate compliance pending appeal. Number 3-2 they were supposed to use, which they failed to use, is filed a motion, experts seeking a right of compelling the DSS to produce him in court or release him. Now, the last two which they're supposed to use, they did not use was they were supposed to use a certificate of judgment to, initiate enforcement with the bailiff of the Federal High Court. None of these were done in an aggressive or timely manner. The danger of legal compliances, instead of chasing the enforcement, the lawyers engaged in a media parade of interview. Instead of doing these legal things, instead of enforcing the judgment of the appeal court that would have secured Kanu's release permanently, the lawyers engaged in a media parade of interview and statements, giving the public the impression that the battle was over, when in reality the DSS had simply ignored the judgment. I don't know if you guys understand. There was a time that they said Kanu was released. The lawyers of Kanu, I mean, if AJ4 and Mike came out to say that Kanu was released, everybody was happy. Everybody had that impression that Kanu is totally free. And after some point, we heard that Kanu was arrested again. I don't know if you guys understand. So now, instead of them to do what they were supposed to do as a competent lawyer, what they did was they started engaging in a media parade of interview and statements, giving the public the impression that the battle was over, when in reality the DSS had simply ignored the judgment. When appeal court released Kanu at first in October, DSS refused to comply. There were some things they were supposed to do as a competent lawyer to make DSS comply to the ruling. They went and started announcing Kanu's release, when in reality, DSS had simply ignored the judgment. They have refused to comply to the judgment. This gap between public and perception and legal reality benefited the federal government, because public press slowly faded, or public pressure slowly faded. The government's counter move was that the federal government quickly filed. This was what they did. How they outsmarted Kanu's lawyer. They rushed and quickly filed a stay of execution application at the Supreme Court. This was a predictable step. But Mike and Ejiofor camp did not act swiftly enough to neutralize it before it was heard. I don't know if you guys are understanding me. There was something the lawyers need to do, the then lawyers of Nnamdi Kanu. They didn't do it. They lost the opportunity. And then the federal government outsmarted them, quickly filed a stay of execution application at the Supreme Court. This was a predictable step. But Mike and Ejiofor camp did not act swiftly enough to neutralize it before it was heard. You will not know whether they knew that they were supposed to do some things to secure Kanu's release. You don't know whether they did not know. We can't tell. Because you know that there are many sabotage within Kanu, people that claim that are his lawyers, that claim that his supporters. They are not. These people are sabotage. So now we don't know if they actually did this thing deliberately or not. These lawyers, the then lawyers of Kanu. So now they didn't act strictly to enough to neutralize it before it was heard. In effect, the window of opportunity to physically secure Kanu's release before the stay was granted, before it was granted, was wasted. Now, why are they blaming Aloy Ejimako? By that time, was not in, he was not in Abuja defense. He was not, or by that time, was not the Abuja defense. He was not the Abuja defense team. And he had no access to the main file, Kanu's file, or mandate to act in that specific appeal. So no one should come and blame Aloy Ejimako, because at that time, it was not his defense team in Abuja. He had no access to the case file or mandate to act in that specific appeal. He cannot just walk into the court uninvited. Yes, now, the two people that was there was Ejiofor and Mike. They had access to the case file. Asking him to enforce a judgment that he wasn't briefed on is absurd. It was like, firing a goalkeeper and then blaming him for, conceding goals after he left the pitch. That is just exactly what they're doing by blaming Aloy Ejimako, because as at that time, he was not the Abuja defense team and he had no access to act. He has no mandate to act in that specific appeal. He had no access to the case file. So no one should blame Aloy Ejimako. Now, some of you don't know the cost of that failure. This gap they just left. There's a loophole in Kanu's case, and this is the effect. This is the cost of that failure. The lost enforcement opportunity means Kanu has remained in DSS custody for years, longer than necessary. That loophole, that loophole they created has made Kanu remained in DSS detention for years, longer than necessary, despite having two major legal victories in his favor. I don't know if you guys are understanding. The loophole these two lawyers created, the gap which they created, which the federal government now fitted in by filing a stay of execution application. It's till today, Kanu has remained in DSS detention for years, longer than necessary, despite having two major legal victories in his favor. The victories he had in his favor was the Abia State High Court judgment on extraordinary redemption. Two was Court of Appeal judgment ordering immediate release. The second one was more powerful legally, but the power was never exercised. In the future, when legal historians examine why the October 2022 judgment didn't change Kanu's fate, the question will be, did his lawyers exhaust every legal remedy to enforce it? That is the law. That's what people are saying now. Why is Kanu still in detention? US observers will be like, why is Kanu still in detention when he was acquitted in 2022, in October 2022? When they examine it like that, the question will be, did his lawyers exhaust every legal remedy to enforce it? The answer is, based on court records, no, they didn't. That answer will forever stain the legacy of those who held his defense at that critical time. That answer that they did not do anything to, exhaust every legal remedy to enforce it. They did not do anything. It's going to stain forever the legacy of those who held his defense at that critical time. Now, this is why the public must demand answer from these two lawyers. This is not about settling personal scores among lawyers. It's about, transparency and accountability in a case that affects millions of people emotionally. Because when I actually heard that Kanu's case is actually affecting many people emotionally. When I heard that he was, yes, his trial, he appeared in court on the 18th of July. I won't forget. When I heard that he appeared in court on the 18th of July, after so many weeks, then the lawyer said he's going to appear and then, rule on the no case submission. We now heard that the judge, Justice Motosho, was going for vacation. Just like that, 2 months. I was so emotional. I cried that day. So I was like, this man, Oyendo, will still be in detention till October. And a judge be going on vacation, a case they called accelerated. They were prior that they said it to have accelerated. This is actually bad. It is actually, I felt so emotional. So now, why the public must demand answer is that because this case is about transparency and accountability in a case that affects millions of people emotionally, politically, and historically. If those responsible for enforcement failed, they must explain in specific what they did and why they failed or why it failed. When a court of competent jurisdiction delivers a judgment ordering the release of a detainee, listen to me, guys, listen very well. When a court of a competent jurisdiction delivers a judgment ordering the release of a detainee, the law expects that within 48 hours maximum, the appeal court did that. It was a competent, it was a court of competent jurisdiction. So when the appeal courts deliver the judgment, we expecting the law expects that within 48 hours maximum, enforcement steps should begin. This is because delay gives the opposing party, or this because delay gives the opposing party, in this case, the federal government, time to file counter application or obtain stay orders that could block execution. I don't know if you guys are understanding me. Within 48 hours maximum, the lawyers of Kanu should have enforced or start the enforcement step to secure Kanu's release permanently. But because they delayed, the opposing party now, in this case, is the federal government. They filed a stay of execution. If they acted very well, would have blocked them. They would not have room to file a stay of execution. If they did that, they would have blocked that execution. So Michael and Ifeanyi Ejiofor had 2 clear working days to move swiftly with the bailiff and contempt form and enforcement application. Instead, they gave press briefings and victory speeches which did nothing to physically secure Kanu's release. What's the result now? DSF kept Kanu in detention, citing pending appeal. I don't know if you guys are understanding. Instead of releasing Kanu, DSS now had an excuse. They were now they now cited the pending appeal, which the federal government, they filed a stay of execution. Then it was now time to release Kanu. The DSS now kept Kanu in detention, and then they cited the pending appeal. Why no actual contempt proceedings? They said why is it that no contempt proceedings were launched against them? That's the excuse they are using now. How many of you remember this law that says, okay, I'm going to say it at the end of this live section. In Nigeria, constitutional law, the writ of the okay, is actually a nuclear option for illegal detention. Yes, it forces the detaining authority to physically produce the detainee in court and justifies the detention. That's what that law says. That Nigerian constitutional law. Now it forces the detaining authority, that's the DSS, to physically produce the detainee in court and justify the detention. If they fail to justify it according to the law, the judge orders immediate release. So at that point, DSS were supposed to bring Nnamdi Kanu to court and then justify the court why they detained him. If they failed to give reasons why they detained him, the judge immediately orders the release of Nnamdi Kanu. Now, this writ could have been filed the same day the Court of Appeal delivered its judgment. Imagine when Court of Appeal, it's only a competent person, a competent lawyer. If Kanu had people that know what they are doing, he would have been released long time ago. These 2 people now, they are not Kanu's lawyers again. No. Imagine when the appeal court actually delivered the judgment saying that Kanu, they said that his extraordinary redemption from Kenya was illegal, and then they said they should be released immediately. Imagine after the judgment, and then the 2 lawyers filed the same day. The Court of Appeal delivered a judgment, with a certificate of judgment in hand and a high court judgment in Abuja, issuing the order, putting DSS in a very tight legal corner. Kanu would have been released if they have filed that, DSS should bring Kanu to court, and then if they fail to actually enforce, or if they fail to defend or justify why they held Kanu, the judge would have, would immediately order for Kanu's release. But they did not do this. This writ could have been filed the same day the Court of Appeal delivered a judgment. With a certificate of judgment in hand, a high court judge in Abuja could have issued the order, putting DSS in a very tight legal corner. Mike and Ejiofor never filed it. That single omission allowed DSS to ignore the court of appeal judgment with no direct personal consequences to their leadership. I don't know if you guys are understanding me. That thing they missed, that omission, allowed DSS to ignore the court of appeal judgment. So if you're asking why is Kanu still in detention, even as and despite the 2022 release, when the court of appeal actually released and acquitted him, this was the reason. The two lawyers, they omitted something that allowed DSS to ignore the court of appeal judgment with no direct personal consequences to their leadership. The DSS Director General is not above the law. Yes, nobody is above the law, not even him. If the defense team, Mike and Ejiofor, had filed Form 48, that's the notice of consequences of disobedience to court orders, followed by Form 49, that's the motion to commit for contempt, the court could have summoned the DSS DG to explain why the judgment was ignored. But they failed to act. They failed to file the Form 48 and Form 49. Even if he failed to appear, even if the DG failed to appear, it would have created a public scandal and increased pressure on the government. International media would have reported that Nigerian secret police chief faces contempt over court defiance. Such pressure works, but it was never applied. Imagine if these two lawyers of Kanu then filed all these things. Kanu would have been released. In political sensitive cases like this, time is the enemy of justice. Time doesn't wait for any man. If you delay if you delay, your enemies will fit in and they will outsmart you. That was what these lawyers of Kanu did. They delayed. Federal government outsmarted them. That's the reason Kanu is in detention, even when he's not supposed to be there. By this time, in political sensitive case like the one of Kanu, time is the enemy of justice. Every day that passes without enforcement strengthens the government's position. The public forgets. International outrage fades. The government can file multiple applications to stall execution by not acting within that narrow. By not acting within that narrow window. Mike and Ejiofor allowed the federal government to control the narrative and actually pace. So this was how they sold this case to the federal government. Now this is the misleading word. They tell you that they will tell you that we have won the narrative. Immediately after the Court of Appeal judgment, the defense team celebrated as if the case was over. They were celebrating as if the case was over. This gave the Biafran public and IPOB supporters false hope that Kanu would be home in days. I remember when they said they have released him, people were thinking that we'll see Kanu come out in television to address the Biafrans. But we did not see him. Kanu was still in detention. We didn't know that DSS actually ignored the ruling of appeal court, the judgment. So immediately after the judgment of the Court of Appeal, the defense team celebrated as if the case was over. This gave the public, the Biafran public and IPOB supporters false hope that Kanu would be home in days. Many people reduced pressure on the FG because they believed legal victory. They believed immediate release of Kanu. When nothing happened, anger shifted from the federal government to IPOB leadership, causing division among supporters. This is how misinformation, even unintentional, becomes a weapon for the oppressor. Now, it is standard practice for the federal government to file an application of stay of execution in a high-profile case. It is standard practice for the federal government to file an application for stay of execution in a high-profile cases. This was predictable. The defense team should have anticipated it and enforced the judgment before the stay was granted or before the stay of execution was heard. Instead, the federal government's stay application was heard without any urgent counter-enforcement by the defense team of Nnamdi Kanu. That was the turning point. That was the turning point. Some have tried to blame Barrister Aloy Ejimaka, like I said, for not enforcing the judgments. That is very wrong. Like, it's factually very wrong. Factually wrong. At that time, Ejimako briefs was no, like his briefs was the extraordinary redemption suit in Abia State, a separate matter. That was his own, that was where he was defending Nnamdi Kanu in Abia State at that time in October 2022. He was not part of the Abuja appeal team handling the Court of Appeal case. He was not part of it. You cannot legally enforce a judgment in a case where you have no filed appearance or instructions. Shifting blame to him is not only dishonest, but always legally illiterate. The failure to enforce that October 2022 judgment is not just a technical legal blunder. It is a human tragedy. Number one is Kanu's health was reportedly deteriorated in DSS custody. That was number one. His right to fair hearing and freedom has been violated repeatedly. His continued detention has fueled unrest, economic disruption in the southeast, and deepened mistrust between the Igbo people and the Nigerian states. One-time illegal enforcement in the 2022 could have prevented 3 more years of detention and suffering. Calling for the defense lawyers to explain what they did after the October judgment is not a witch hunt. Accountability is not hatred. So I actually believe that that these two lawyers could come out and explain to the public why they did not enforce that. They came out and told the public that the case of Kanu was over and has been released. Why in reality, he's still in DSS custody. DSS ignored the judgment. I feel they need to come and explain why they did not enforce the judgments of October, the Court of Appeal judgment in October 2022. It's about setting a standard for legal accountability in political trials. If lawyers handling a high-profile political case fails to enforce a victory, they must explain why in details with evidence. This will prevent future lawyers from repeating the same mistakes. So these two lawyers must come out, it would be very nice if they come out to explain why they did not enforce that, victory, Kanu's victory. The October 13, 2022 judgment by the Court of Appeal was not an adversary option. It was a final binding order on the federal government of Nigeria. The court didn't just suggest that Kanu should be released. It was not a suggestion. They did not just suggest that Nnamdi Kanu should be released. It's categorically discharged him of all charges and barred any further trial over the same issue. Legally, once that judgment was delivered, Kanu's continued detention became unconstitutional and, it became illegal, unlawful. When a lawyer secures such a victory, the immediate next step is to file enforcement motion, contempt proceeding, urgent application to compel compliance. They would have filed an order for the DSS to comply. None of these steps were seen from Ejiofor and Mike. Instead, the matter went into limbo, allowing the federal government's time to seek a stay of execution, which ultimately neutralized the victory. The federal government wasted no time in filing an application. You can see how they outsmarted them. They didn't even waste time at all. Would I say this was deliberate? They did not waste time at all. They did not delay, but the lawyers of Kanu delayed to enforce his victory. The federal government wasted no time in filing an application for stay of execution, a legal move to stop the judgment. An aggressive defense team could have immediately opposed. If they were truly in support of Kanu, if they know what they were doing, they would have, immediately opposed it with speed and multiple layers of enforcement, filing in other courts, international films, and using diplomatic, pressure simultaneously. Instead, they were, what they did, they delayed, during which the DSS continued detention as though the judgments never happened. DSS still kept Kanu as though the Court of Appeal never came out to release him. Aloy Ejimako, though, was sidelined from Abuja case. This is why I'm still saying that nobody should call his name. Demonstrated a different legal style in Abia State High Court. Sweet filing, he won the case self. He won the case. He talked about the extraordinary redemption, which he won in Abia State. Strategic arguments, and what he did was he acted swiftly. Strategic arguments and leveraging international law principle like extraordinary redemption. That approach produced tangible wins. Even if the federal authority refused to respect them, the principle remains speed plus persistence matters. Why Kanu's case has politically overturned, or why Kanu's case has politically overturned, lawyers still have tools to enforce compliance, including filing committal proceedings against DSS officials, escalating to the ECOWAS courts, and mobilizing public pressure with documented legal demands. The absence of such tools being deployed shows either a strategic failure or a deliberate sabotage. It's either these lawyers failed, or they deliberately sabotaged Nnamdi Kanu. For many people, Nnamdi Kanu's illegal detention is not just about one man. It's about the Nigerian state's contempt for Igbo rights and the larger Biafran question. A squandered legal victory doesn't just hurt Kanu. It sets a precedent that even clear-cut wins for Igbo courts can be ignored if not enforced. The refusal of Mike and Ejiofor to publicly detail any enforcement step raises questions about transparency. So we expect them to come out and tell the public why they did not enforce Kanu's victory. If they took action, they could easily publish the motion, letters and application filed, yet the public see none. If they did this thing, if they actually enforced the rule, they should come out and tell the public. In legal practice, if it's not on the record, it didn't happen. It didn't happen. Now, at that time, the media could have amplified the pressure by continuously asking, why is Kanu still in DSS custody after a binding judgment? Instead, the narrative was allowed to drift, and the federal government successfully shifted focus away from their contempt of courts. The Court of Appeal judgments aligned with principles of extraordinary redemption in legality under international law. Lawyers could have immediately taken the certified judgment to the African Commission. These two lawyers, this is what we expected of them. They would have taken, his extraordinary redemption. They would have taken the certified judgment to the African Commission on Human and People's Rights and the United Nations Human Rights Committee to demand sanction or pressure against Nigeria. But they didn't. Delay here allowed Nigeria to argue domestically, because those bodies that the case is still in court, they are saying the case is still in court, effectively buying themselves impunity time. Weak follow up on political pressure channels. In political sensitive cases, lawyers sometimes partner with influential political figures, foreign governments, and advocacy groups to link compliance to diplomatic relation or aid discussion. No visible coalition was built to keep Kanu's release at the center of Nigeria's intentional image. No visible coalition. The DSS deliberately restricted Kanu's access to visitors, legal team and journalists, controlling what the public knew. This made it even more important for the lawyers to publicly file motions and publish them. So the public could see the step taken. Without that transparency, without the transparency, DSS narrative dominated. No emergency application for enforcement. Nigerian law allows an expert motion in urgent matters to compile and to compel compliance where a party is unlawfully held. Even if the federal government filed for stay, an emergency enforcement application could have challenged the stay on constitutional ground, especially under the section 35 of the 1999 Constitution on personal liberty. Okay, even if they did not file it immediately, even if they filed after some time, after the federal government filed the stay of execution, it would have challenged the stay of on the constitutional ground, citing section 35 of the 1999 Constitution on personal liberty. The 2022 judgment sparked celebration in the East, raising morale and unity. Lawyers' failure to immediately capitalize on that moment to allow the public energy to die down. And when energies die down, so does political leverage do as well. The impact on futures agitation case. Now, this message to other pro-Biafran activists was very clear. Even if you win the court, without aggressive enforcement, you can still rot in detention. If you don't enforce it, you will rot in detention. This discouraged people from trusting the Nigerian legal system, making peaceful legal resistance weaker. Now, if a lawyer has hidden political or financial ties to the opposing side, their legal strategy can be international, slowly, or ineffective. In high-profile political cases like Kanu, it's crucial for the defense team to be beyond suspicious. But in Kanu's case, the conflict of interest whispers have never been convincingly addressed. The missed chance to file contempt charges against DSS officials. The Nigerian allows naming specific DSS, the Nigerian law allows naming specific DSS officials in contempt proceedings, forcing them to appear personally in court. This is a powerful tool that that the lawyers had. No DSS Director General wants to stand in the dock, but it was never used when they had the tool. So this is how Kanu's case was sold to the federal government. There was an omission. There was a loophole. A loophole. That was when Kanu. That was when Kanu. That is why Kanu is still in detention. The federal government, there was a loophole, and then the federal government filed a stay of execution. That's why Kanu is still in detention till today. So guys, you can see how the lawyers of Nnamdi Kanu sold his case. Now, I want to do this special announcement because we have come to the end of this live section. Now, tomorrow we'll be we'll be bringing up people to speak. We'll bring up people to come and speak and talk about their opinions. So get ready. We'll be live by 2, and as well we'll be live by 8:30 as well tomorrow. So we'll bring up people to come and speak and talk about their own opinions here. So I want everyone, because I would love everyone to come and share these our own ideas on tomorrow headline. So guys, don't mix tomorrow's live, because I'll be live here again by 2:30 and then by 8:30. So don't miss it. I'd love you guys to come up and speak and share your own ideas. Just note that YouTube don't accept harmful words, or this YouTube don't accept harmful words, and they don't accept how will I put it, unguarded words. So you should mind what you talk about. So tomorrow, I can't wait for tomorrow for me to hear you speak, and talk about your own thoughts. So we have come to the end of this live section. Do what, hit that subscribe button, like and share this video. Thank you guys for staying with me. Thank you so much. Have a good night rest, and I'll see you tomorrow by 2:30 and 8:30 tomorrow. Thank you, and thank you for joining me.